This program is presented by University of California Television. Like what you learn? Visit our website or follow us on Facebook and Twitter to keep up with the latest UCTV programs. Also, make sure to check out and subscribe to our YouTube original channel, UCTV Prime, available only on YouTube.
For prosecutors as well as priests, the way that we have sex has long been a subject of deep concern. And when prevailing community standards are challenged, the response has often been repression and severe punishment. Eric Berkowitz is both an attorney and an author in San Francisco who has studied this phenomenon. His new book is called Sex and Punishment: 4,000 Years of Judging Desire. Eric Berkowitz, welcome to our Legally Speaking series.
Thanks for having me, Marty.
Let's start at the beginning. As far as you can tell, what were the first written laws governing sexual behavior? Who wrote them, and what exactly did they say?
When I first started the research for the book, I was answering that very question. Someone posed to me, what are the first laws, Eric? I have no idea. So I went back and looked, and they governed adultery, they governed people having relations with girls who are promised or betrothed. People were married off very, very early. Maybe they lived in their father's house. Also, strangely, sex with livestock. A lot of that, I believe, of course, we can't know, there are no emails, but that had to do with religious practice. It was an agricultural society, etc. So sex was the concern in one form or another of maybe 20% of the laws that I found, which struck me as a very large percentage.
I mean, it does seem to me that because the sexual urge can be disruptive, it makes sense for societies to want to regulate that behavior so that people can live in harmony with one another. But it seems to me that doesn't begin to explain some of the crazy rules that you describe in your book. For example, in Mesopotamia, the Hittite society, around 1300, 1400 BC, you say that anyone caught having sex with a dog, a cow, or a sheep would be immediately put to death. But that if one were to be caught having sex with a horse or mule, while that is not exactly encouraged, the person who was caught doing that wouldn't be punished in any particular way.
Why a cow
Yeah.
was defiling to the point where society couldn't tolerate this person living any further. That itself causing probably a very substantial disruption, because if he had contact with cows, he might have had a family and land, and etc. Why that created such a defilement, whereas a relationship with a horse or a mule didn't. I mean, to us it sounds utterly almost comical. I can't explain. There must have been, and that's the theory, and a lot of this is just trying to deduce from the thin records that we have a religious significance to one animal and another, especially in Egypt.
You mentioned ancient Egypt. In
Please.
ancient Egypt, having sex with goats was actually encouraged, you say in your book. Again, that was tied in with the religious ethos of that period?
Yeah. Now, our sources for that, the main source for that is Herodotus, who is a Greek traveler and historian who I love, and who everybody who reads loves, known as the father of history and also the father of lies. Although that account is not as disputed as some of his others. He much of what we find in sexual descriptions or in descriptions of the sexual habits of others involve a smirk, involve a cultural judgment, although the goat in Egypt was, at least according to Herodotus, seen as the incarnation of an Egyptian form of the god Pan, and sex with goats, from what I understand, did occur as part of religious ceremonies. No problem with that. I don't know how much farther we can take that other than to, through the course of this conversation and through the course of thinking about these things, to withhold ourselves from the automatic sense of moral and cultural superiority that we have over others. We are no wiser than the Egyptians. We're simply different.
Yeah, and I don't want to dwell on this topic, but
I'm happy to talk about it anyway.
But let me ask you this. You say that during the course of your research, you discovered that there are no eternal sex laws, no natural sex laws, that what is perceived as virtuous in one culture can just as easily be perceived as unnatural and sinful in another. Did that surprise you?
Yes, it did. It did. And this is a very large debate in this new field of historical endeavor, which has really crept up in the last 50 years, which is gender studies, history of sexual practices, history of sexual law. It's a very burgeoning field in academia. And one of the main questions is the notion of natural sex law. Is there, the word unnatural is often used against habits or practices that the person who's using the word doesn't approve of. I was surprised, very surprised, that I could not find one practice, one event that everybody agrees or has agreed was wrong. The first thing that comes to mind is incest, which is just the word is disturbing. It's a radioactive subject, and it's a subject that needs to be opened up because we know how much incest goes on in a very abusive fashion with domestic violence, etc. But incest having a scientific basis that no one disagrees with, that outbreeding keeps the species alive, allows us to develop, etc., would be something that societies almost as soon as they began to intermix would all agree on. But I found significant exceptions to that. Now, the Babylonians, the Mesopotamians, the Jews, of course, Christians, incest is the highest order of crime amongst all. But Egyptians, Persians, Hawaiians, various cultures in the New World, incest was condoned, practiced at almost all levels of society. And you can look towards an economic basis for that, you can look towards a spiritual basis for that, you can look towards a lot, but to answer your question, with those kinds of exceptions, Egyptians, especially Persians, these are advanced societies, advanced, sophisticated societies.
You say the Persians actually required incest.
Well, at times, yes.
You write about ancient Persia, any reluctance on a man's part to marry his sister or mother was considered a grave sin deserving of damnation in the highest degree. Now, given what we know about genetics, it seems to me any society that would require incest would be confronted with an epidemic of birth defects. Do we know, in fact, that that's what happened in ancient Persia?
We know that ancient Persia was an immense place with extreme cultural variations. The sources that I found, which said that, absolutely held that. And I don't know, and I don't think we do know, whether those kinds of marriages were exclusive marriages on the man's part, whether there were children produced through concubines, through second or third wives, whether or not that was exclusive. We do know that an incestuous couple were under the Zoroastrian faith, which was quite entrenched, through, at least through the ruling classes of Persia, that there was a sense of blessing, a sense of harmony, a sense of goodness that came from that.
Before we go much further with this, it does seem to me that no discussion of sex and punishment would be complete without showing a clip from the Ten Commandments with Charlton Heston. Actually, my mom took me to see this film at a very impressionable age, and I remember one scene in particular. This is the scene while Charlton Heston is up there receiving God's law. His people down below are kind of falling back into pagan ways. They construct a golden calf to worship, and then they proceed. They
melt their jewelry down to it.
Right, right. How they brought that equipment into the desert with them is hard to know. But
with their matzah, they brought a kiln.
Yes, and then they proceeded to have what I would describe as a PG-rated orgy.
I think it was M back then.
Yeah, that's exactly right. As M. Anyway, let's take a look at that clip, and then we can talk about it.
And the people rose up to play, and did eat and drink.
Here's my question, though. In this movie, it's strongly implied that these pagans were having one hell of a time. That they were having this nonstop orgy, and then the Jews came along, and that they represented a radical break from all of that. Is that in fact the case?
There was a sense that pervades Jewish law, that sex is a blessed thing when it's engaged in solely to make more Jews. Okay, that sex, and there's nothing wrong with feeling pleasure as you engage in that, but when you veer off from the business of procreation, it becomes a sin, and that has huge, huge consequences.
That didn't preclude, obviously, polygamy.
No, we spoke about that. The Jews also were not cut from different flesh from those around them, and polygamy was a custom. Polygamy was also a way to generate offspring with volume, and polygamy was accepted.
I mean, in the Bible, it says that King Solomon had 700 wives and 300 concubines. That to me seems more consistent with the idea of exhaustion than restraint. But
it was also an indicator of wealth.
So, okay.
It was
but help me out with this. How is a society that embraces that kind of conspicuous polygamy maintain a view of itself as a restrained culture?
The polygamy was an entrenched Middle Eastern custom that was not necessarily seen as overt lasciviousness or license. It was simply a man having a number of wives. Now, Solomon and the myth of him having hundreds of wives and thousands of concubines. Well, that's an indication of power and position. The Jews very much accepted that a woman had to be faithful, the man had to be faithful, but it's a paradox. He was also allowed to keep several wives and then, in that sense, produce more children, which was absolutely necessary.
And also, of course, the Jews held on to their slaves. There wasn't an 11th commandment that says, thou shalt not have slaves, right? And wherever there's slavery, there's going to be sexual abuse along with all kinds of other abuses, right?
Yes. Sexual submission is part of the job description of a slave.
Do you think it's almost like a law of physics that the more restrained and more puritanical a society tries to be, the more hypocritical it becomes?
In that sense, I think yes. In that sense, I think that as the law sets ideals and sets goals that can't be met, or that almost surely can't be met, you're setting up a society in which law breaking becomes a very regular thing, and we see that as we go into the Christian era. We see that as we go into the early modern era, when in the 17th century, when the amount of sexual restrictions multiplied, at least in Europe, by many, many times. The more laws you enact, the more opportunity you create for law breaking. And also, the sexual urge, as we're talking about, stands apart from most others. It's
yeah, so when we get to the Christians many centuries later, what great or perhaps not so great things did they bring to this idea of restraint and perhaps hypocrisy?
Most of the great Christian fathers were at one point ascetics, at one point monks living in the desert. Egypt was and St. Augustine, who I focused on, whereas Christ himself said precious little about sex. Precious little about sex. Those that carried and developed a religion in his name said quite a bit. Augustine tied the sexual urge to original sin, tied the sexual urge to the manifestation. This goes back to
the Garden of Eden,
to the myth of the Garden of Eden, where Adam disobeyed God's command and thereby tainted the rest of us intrinsically. And Augustine, who was a bit of a libertine in his younger days and had a concubine for years, with whom he had a son, and it's in his confessions, had a very, let's put it, a vigorous sexual adolescence and manhood, young manhood, saw the genitalia and the sexual urge as a punishment, saw it as a manifestation of the devil entering the human spirit. And to that extent, holiness, to that extent, a good Christian life, to that extent, a life lived according to God's commandments, entailed a resistance to the force of the devil, which was the sexual urge. If anything could create neurosis in our current terms, that's it. And reaching even further back to Paul, he wrote, "It's better to marry than to burn, but not much."
I suppose, though, in one sense, Christians were more equitable about how they viewed sex between men and women. They held both sexes to standards that were virtually unattainable.
Correct.
And I suppose, and the interesting you
and
talk
in a
about,
sense, you're right. That traversed both genders.
So that in that sense they were progressive, I suppose.
At the same time, and we could talk about the two-faced aspect of all this. The church went into the prostitution business in the Middle Ages, and the justifications for that are comical. But for example, the tax on prostitutes, even Rome made pretty good money from taxing its prostitution, and the tax on prostitutes remained well into the Christian era. And so, yes, we don't like prostitution, except for when there's some revenue to be made.
When the Protestants came along and started to draw attention to this gap between theory and practice, did the Catholics have to sell off their brothels?
Well, it's interesting. That's a great question. The answer is yes, and I'll tell you how that happened. The Catholic Church obviously was highly disturbed. I mean, a stupid understatement. There created enormous problems in the 30 Years' War, et cetera, in Europe. And there became sort of a one-upsmanship between Catholic and Protestant societies, a moral one-upsmanship. The Catholic Church retreated into what's called the Council of Trent, a 20-year council where they were trying to deal with the challenges from the Reformation. And rather than admit, adjust, loosen up, they doubled down.
Over the past year, there was one gentleman who ran for president who was Roman Catholic.
I've heard about him.
Yeah, he wasn't shy about expressing his views on sexuality and sin. He talked about abortion, he talked about homosexuality, and he also talked about birth control. We actually have a clip of him doing just that, And why don't we take a look at that and we can then talk about it.
I'm a Roman Catholic. I do my best to live my life in conformity with my faith. The Roman Catholic faith teaches in Humanae Vitae that we should not interfere with conception. We should not practice contraception, artificial contraception. That's what the Church teaches, and that's what I and my wife of 21 years abide by. And that is my moral judgment, but it is not one that I feel that should be or will be imposed on anyone. So I would not vote, and I've said this repeatedly, although this doesn't seem to quite make it into the left-wing blogs. I have said repeatedly that I would not vote for banning contraception. That is an individual decision. Contraception can and should be made available. I, because of my faith and faith convictions and because of what my church teaches, do not participate in that. As far as the other issue, which goes back, let's go a little deeper, this was the Griswold versus Connecticut case, which I was asked about, which created a new constitutional right, which in my opinion is judicial activism. Just like Roe versus Wade was judicial activism, just like the Kelo decision was judicial activism, which is a group of people creating rights in the Constitution that don't exist. We have a way to create new rights, and that way is through the constitutional amendment process. I don't know how any reasonable person can say that the founders intended a right to an abortion in the Constitution when they wrote it. I mean, it would be beyond fantasy to think that that's what the writing of that constitutional document meant. So if the Supreme Court wants to change things, then what they should say is, we write papers about it and say we think this is a bad idea, but it's up to the people to make these decisions. And so with respect to contraception, I thought the Griswold decision was wrong. I don't care what it was about contraception or anything else. It was just creating a right that didn't exist. And so does the state of Connecticut, in that case back in 1953 I think it was, have the right to pass this bill? Well, the answer is yes, they have the right. They shouldn't do it. I wouldn't vote for it. I think, I can't imagine, I think at the time of Griswold, I think contraception was universally available. Laws weren't enforced, and that's one of the reasons you don't want to pass laws that aren't enforceable laws, even whether you may think that they're moral or not. And so, understand that just because you say something you believe is morally wrong doesn't mean it should be illegal or there should be any kind of laws about it. And I don't believe there should be any laws about it.
That was, of course, Rick Santorum.
One of the most confused.
He was conveying a
I've
bit
ever
of a
heard in my
mixed
life.
message, it seemed to me, in that clip. On the one hand, he said that he would not vote to prohibit birth control, but then he went on to suggest that people didn't have a right to birth control. It's just simply that he didn't think a law to ban birth control would work.
The first thing he said was, personally, I don't believe in birth control because that's what the church teaches me. That's fine. At the same time, if you take what Santorum said with what he was saying probably earlier that day, later that day, and throughout his hundreds of speeches given during his short-lived campaign, he was very much for using the arms of the state to enforce moral strictures that had an essentially religious basis.
It seems to me wrapped up in the history of sex and punishment is the history of how women's rights evolved. And whether we're talking about Greece, say 500 years before the birth of Christ, or we're talking about 17th century England, women were essentially viewed as property. When would you say that began to change?
Well, no one rings a bell when society evolves, and it evolved, and it still is, in a very, very patchy way. And I would say that when the ideals of reason began to replace the Bible as being, let's just say, after the 18th century, after the revolutions in France and America, that became a harbinger of what was going to come, which was the recognition of a right of privacy. But let's step back a little bit. The notion is not just that women are property. Lots of people were property, both men and women. The notion is of what a woman is, and how and whether or not as a woman she actually has the same value that a man does. And a lot of it is tied up with notions of science and notion of what a woman's role in reproduction is. Reaching back to Aristotle, which is probably the first source we can find, his belief that a woman did not have the same role in reproduction that a man did, that a woman was essentially a vessel to be quickened by a man's sperm, that Sophocles called a woman a field to plow. The notion is that a man has, if not 51%, 61% more to do with reproduction, that the child is the man's and the woman is essentially an incubator. And that notion of a woman being less of a person in the reproductive sense than a man, that's where law begins to find its justification. And the notion that a woman is there to be dominated, to be used, to be managed, to be husbanded, that is what is, I think, motivates a lot of what if we want to call the misogynistic strain in Western law, which I recognize very much from the beginning. So the notion of a woman being, if not property, being of a lesser value, and is the basis for a lot of biblical injunctions. A woman after her period or during her period being essentially unclean, a woman to be dispensed with and kept, a man's belief that his significant connections are with other men, not with women, women being less intelligent. I think we're still contending with that now.
Yeah, and as you say, it's something we're still wrestling with. I noticed, I don't know if I read it in your book or a paper that you had sent me, that the idea that a man could be found guilty of raping his wife, that is a very recent notion. That it wasn't until 1980, for example, that the California legislature passed a bill overturning the marital rape exemption. So this is something...
It's just astonishing. This, yeah. I think, shows how far we've come in a very short period. We're sitting here at Hastings. One of the most illustrious professors of Hastings was Rowan Perkins, who wrote the book that I read and that every law student of my vintage from the 80s read on criminal law. He wrote the Horn book on criminal, and in the edition of his that I read was from the late 50s, and it held without, it didn't hold, I mean, it identified without really much discussion that once a woman said, I do, or once the marriage began,
she has to.
Well, if it's not even a question of whether she has to, she doesn't have the right to object. That even, and Perkins said, even if violence is used. Now, the whole notion, I've been involved lately in a lot of domestic violence cases, the whole notion of there being, of a woman having a right against her husband, or if you want to extend that, against her father or her brothers, to be safe from the predation of the men around her, is very, very new. And we have to realize that these rights are hard won, recently won, and easily lost.
Let's talk a little bit about homosexuality. As we all now know, President Obama is fully evolved on this issue. He has now come out and has said that he believes that same-sex couples should have the right to marry if they want to, that heterosexuals shouldn't have a monopoly on misery. That's how one of my colleagues put it. There are also about a half dozen states in this country where same-sex marriage is legal. There are about as many countries in Europe where it's legal.
And there still are a number of candidates advocating for a constitutional amendment to invalidate those state laws.
Mm-hmm. But to give the social conservatives their due, this phenomenon that we're seeing where same-sex couples are gradually winning the right to join in formal marriages, over the course of human history, that is an unprecedented phenomenon, is it not?
Yes, it is. And well, there are precedents, but not large ones. I searched hard and found some strains of devotional male relations being sanctioned by the law and by the church, but they're remarkable for they're an exception that almost proves the rule.
One of the most famous sex trials of all time, of course, which you describe in your book, was the trial of Oscar Wilde.
Yes.
He was the most famous playwright of his era. He was also a homosexual, and in 1895 he was hauled into court on a charge, they called it gross indecency. I know of at least 2 movies that were made about his life, the latest of which was in 1997, starring Stephen Fry in the lead role. And so before we go any further, I would like to play a scene from that movie. And this is a scene where Wilde is being cross-examined about the letters that he has been exchanging with a young man that he's been having a relationship with. And in this cross-examination, Wilde, played by Fry, gives this very eloquent response.
So is it not clear that the love described relates to natural and unnatural love?
No.
Oh. Then what is the love that dare not speak its name?
The love that dare not speak its name in this century is such a great affection of an elder for a younger man as there was between David and Jonathan, such as Plato made the very basis of his philosophy, and such as you may find in the sonnets of Michelangelo and Shakespeare. It is in this century misunderstood. So much misunderstood that it may be described as the love that dare not speak its name. And on account of it, I am placed where I am now. It is beautiful. It is fine. It is the noblest form of affection. There is nothing unnatural about it.
I don't think that exchange went exactly the way the prosecutor hoped or intended. But watching that, it occurred to me that...
By the way, that is the exact transcript.
Is that right?
Yeah.
The thing that struck me, though, apart from its eloquence, is that Wilde was not being exactly truthful. And what I mean by that is he made it sound as if he was having a platonic relationship with this man, a spiritual, an intellectual relationship, and of course that wasn't the case at all, right?
No. Can I give a little bit of background?
Sure.
Oscar Wilde is now part of the canon. If you're well-read, you've read Oscar Wilde. He was indeed a very successful playwright. When this trial happened, or just before it happened, he had 2 hit plays running at the West End of London and in New York simultaneously. Those were parlor comedies that were interesting. His novel, The Picture of Dorian Gray, did not do well when it came out. Its glorification of a beautiful young man who sells his soul to guard his beauty was really criticized when it came out.
Kind of a downer, right?
No. Well, it's interesting. The downer part of it wasn't, I mean, Dorian Gray comes to a very bad end
Yeah.
in the book, but that part was forgotten. It was the endless passages about the beauty of his mouth and the lips, and also that Dorian Gray, when he sold his soul, went out and had what was clearly gay relations. This is a fascinating case for 100 reasons. It is a fascinating case because it comes just at the time that I was discussing a moment ago, when the identity of a homosexual was being crystallized. And in England, homosexual meant pretentious, upper class, snobby, removed from the honest, bucolic English spirit that people were trying to recall. That clip turned out very well for Oscar Wilde because that was in his second trial and there was a hung jury. He wasn't convicted until the next trial. He actually did get applause. But honestly, Oscar Wilde was loathed by the populace. When he was finally convicted, there was dancing in the streets. Every newspaper said, "Open the window, let in the fresh air. We've had enough of men like this." Oscar Wilde has to be put in context. His trial was in 1895. About 15, 20 years earlier, there was a bust of a male brothel in which some very highly placed men, it's called the Cleveland Street Affair, were put on trial and were accused of patronizing this brothel. And one of the aristocrats that was accused brought a libel case against the newspaper that named him, and he won. Now, in the intervening 15, 20 years, there was a law passed which penalized gross indecency in private. Okay, the tradition in England was sodomy was a death crime under Henry VIII. Well, because it was a death crime, there were some very colorful trials, but as life evolved, it became too much. You couldn't, I mean, people were against it. They didn't think people should be killed for it. Eventually, the penalties were reduced, and as a last-minute add-on to a case that had nothing to do with homosexuality against taking advantage of young girls, there was a little amendment thrown in at the last minute, prohibiting gross indecency and making that worthy of 2 years of hard labor. That seemed enough to people. Oscar Wilde lived an extraordinary life. He was married, he had 2 children. He also loved rough boys. He had a real taste for working class young men. He exalted them in the language of Plato. He was talking about Plato's Symposium. And Plato being the great exponent of a spiritual, true, good union between an older man and a younger man.
The young man that he was involved with that was the subject of this trial, though, was not a working class young man, right?
No, his name was Lord Alfred Douglas, affectionately known as Bosie, who Alfred Douglas and he had a great love. They also had an apartment in Piccadilly where they would receive young men, and Oscar Wilde gave them gifts. They had sex, and that was they were slumming it. They were enjoying that. Bosie's father, a very truculent man known for penning a sense of boxing rules, made it his mission in life to bring down Oscar Wilde. He accused Oscar Wilde of being a sodomite. Oscar Wilde brought a libel case against him,
and that was
clearly thinking about the Cleveland Street affair. And I think Oscar Wilde saw life as a great feast. He was the most clever person going. He probably thought he would, simply have sport in court and vindicate his name and have some fun and drive the crowds to his plays. What he didn't say was the truth, is that under the law, he was committing gross indecency and he lied. I don't think the lie was, one's personal opinion about gay sex, that's something else. But his lawyer asked him at the beginning, is the accusation true? And he said, on my honor as a gentleman, it's not. Brought a libel case, lost it when his opponents began to, he had been blackmailed for a long time by the rough boys bringing these letters out. And he lost it, and then as soon as he lost it, there was a warrant issued for his arrest. That speech came in his first trial for gross indecency. All during the case, his friends were saying, please leave. You can escape. In fact, the prosecution held back a little bit before they arrested him to let him go. His mother said she would never speak to him again if he left. And I think he That's one of the all-time
Yeah.
hubris, you know,
He was, to a certain extent, the instrument of his own downfall.
Entirely.
Yeah.
And within weeks, well, he was also, having lived this remarkably wealthy life, he belonged to 100 clubs and ate in the finest restaurants. He was terribly in debt. Within weeks, all of his property had been sold. His wife and his children were in disgrace. And he did 2 years at hard labor. So his use of the Platonic ideal in court showed his, it's a gorgeous speech and I'm glad it was said, but it showed his complete lack of integration with the spirit of the times. He helped crystallize the image of the homosexual as being a predatory, snobbish, effeminate fop.
Mm-hmm. In another chapter in your book, you write about a guy named Anthony Comstock,
My favorite.
who lived in the 19th century and championed what was perhaps the first great anti-obscenity crusade in the United States. Talk a little bit about him.
I wouldn't say it was the first, but I would say it was
First great.
the most successful, let's put
Okay.
it like that.
Okay.
Anthony Comstock was a dry goods salesman from Brooklyn who had a shop and never did terribly well. He was also a compulsive masturbator as a child.
How do we know that?
He wrote it.
Oh, he wrote about it, okay.
And he wrote a lot. And he...
And masturbated a lot.
Well, I guess so. Yeah. And he felt when he did, and that was also, his career high was between about 1873 and 1903, 1904. That was during the scientific era of masturbation being physically harmful. And masturbation somehow resulting in a depletion of vitality.
Well, the ancient Greeks believed that, right?
I don't think they had any belief about that, one or the other. The notion of masturbation being a medical risk really came into belief in the 18th century with a doctor named Samuel Tissot, who wrote a book called Onanism, which became like a mess.
But like the Greek athletes, weren't they encouraged to be abstain before a great athletic event?
I wish I could say I knew. I really don't.
Okay.
I doubt it. But at the same time, pornography was linked with masturbation, as of course it always is, and was considered, it had the scientific imprimatur of being, those that worked against it were able to say, and this is harmful. And so Anthony Comstock was a true believer in that pornography was a bad thing. He teamed up with the YMCA in the 1870s and took the example of a recent act in England which allowed authorities to seize obscene matter, and on the spot. America, I don't think, was any less against pornography than England. They just didn't have the legal tools. So on the basis of the Commerce Clause, a clause that's being debated quite a bit these days, the far reach of it, he pushed through with the YMCA a law which is called the Comstock Act, which empowered the Postal Service to intercept and impound and allowed the federal government to prosecute those that transmit obscene matter through the mail. Now, there was no internet, the mail was everything. So with that authority, Comstock was off to the races. What a shock, he became the main enforcer for the Postal Service and became the face of it. Now, the key thing is the definition of obscene is always a squirrely thing. We're still wrestling with it. I don't have it memorized, but the definition of obscene was as wide as it could be in that act. And it didn't just include material of a sexual nature, it also included scientific and birth control information. Now, whereas actual birth control information had nothing to do with eroticism, that all fell within the ambit of the Comstock Act. Comstock became an unbelievably energetic prosecutor, constantly bragging about the tonnage of vampire literature that he would confiscate and the people that he arrested, and it worked. And for a while, he had popular backing. The New York Times as it was expanding its readership from the upper to the middle to the, as literacy expanded, people were buying newspapers. They assumed a more popular tone, and they were behind him. And he was like a steamroller. I mean, it was unbelievable. And so, at some point, people began to tire of him. He began to be seen as a monomaniacal buffoon, as opposed to a guardian of public morals. But before that arc played itself out, there were a lot of people that were caught within. There was Dr. Foote, Edward Foote, who put out a pamphlet about birth control and that sort of thing, jailed. A woman who wrote a guide for couples to love each other, kind of a stupid little pamphlet, jailed, killed herself. A famous abortionist, jailed. To Comstock, they were rats to be exterminated.
So today, of course, we have the internet, and apart from providing access to a lot of classified legal government documents, it also provides us access with an awful lot of pornography. And according to the surveys that I've seen, what the part of the country that we call the Bible Belt views this material with at least as much avidity as
more.
other parts. Okay, at least as much. So I'm wondering how you think the internet, which has made pornography so much more ubiquitous and accessible, how that has changed the way we view the regulation and repression and punishment of sexual behavior.
Well, to some extent, it's the same issue in a different setting. The first pornography prosecutions that I could find happened in Rome in the 16th century with images that were on the Vatican walls, which were mass-produced. The Vatican thought they had destroyed all the copies, and they weren't. That's always been the case. You can't interdict this kind of thing entirely. It just simply doesn't happen. The internet is simply an extremely efficient delivery system of the same old thing. I remember asking my son when he was 12 years old how quick it would be for him, how quickly he could get around a net nanny that I bought for our home internet. He said, about 4 seconds. And I said, do I need to bother? And he said, it's up to you, but I can get around anything. And so I think, to answer your question directly, it's a question of, we now still have, to define obscenity, we have a community standards issue, where something is, and that was a great advance in its day, where something is determined obscene under prevailing community standards. The idea being that San Francisco would be much more permissive than the Bible Belt, and that people should be allowed to set their own local standards for what they find to be illegal or not. Under Comstock, there were national standards, and not only medical books, but what is now great works of literature, what we find to be great works of literature, were all swept under. Now we have a much more evolved standard, but I think with the internet, we have to rethink community standards. I just last night read about a case, as I was thinking about this, in which there was, I want to say in Oklahoma, there was a prosecution against a pornography dealer, a guy that had a shop for obscenity. Now, a guy who sells pornography in San Francisco is not going to be prosecuted, but he upset local community standards. He won that case. He won that case because he found, his lawyers, clever lawyers, found that in the Marriott down the street, there was a tremendous amount of pornography being downloaded by guests, and that the community standards even of that particular town were not quite so clear-cut as it seemed. So I think, I don't know what it is, but I think the notion of community standards being a definition of what is or is not obscene,
it seems completely anachronistic at this point.
It seems anachronistic, and
Yeah.
since the law is generally 15 to 20 years behind the times, it's going to take a while for the law to digest this
Yes.
and understand it.
If there's one sexual act, it seems to me, that we're considerably more punitive about these days, it's the act of having sex with minors. And in this
Yes.
regard, you mention in your book the case of Roman Polanski, the film director who back in 1977 pleaded guilty to having sex with a 13-year-old girl. He pled guilty. There was a deal in the works, a rather, tolerant deal that I believe it wouldn't have required him to serve any prison time at all.
Any additional prison time.
Yeah. And but then the deal fell through somehow because the judge, Polanski upset the judge somehow. Polanski fled to Europe. She's now in her mid-30s. I believe she's gone on the record as an adult saying that she would be in favor of the charges being dropped. I'm kind of curious, since you write about this case, what's your view on it? Do you think that if U.S. Marshals were somehow able at this late date to get a hold of Polanski, that he should serve prison time?
Personally?
Yeah.
Yes. I think my personal belief is that to be a grown man with a girl of that age, he also put some drugs in her drink.
He didn't mention that.
He didn't mention that,
interview,
but
yeah.
that's critical.
Yeah.
My sense is that kind of abuse of power and influence is unacceptable. Mm-hmm. That's my firm belief. It's a recent belief as far as morality law goes. If he had been caught in California earlier, a century earlier, he would have been in the clear. In the late 19th century, the age of consent in Delaware was under 10. The age in California was 10, and that was the age in most places. There's always been a belief that older men almost have younger women as legitimate prey. In fact, I don't know if we have the time to go into it, but there's incredible stories told in the book about the battles that were waged to raise the age. It wasn't easy. There was a lot of resistance in Parliament and in the legislatures here in the United States. The belief being that this will simply give young girls a way to shake down influential, wealthy men like him. Also, even after the ages were raised, men were given a pass, white men were given a pass often because of that exact belief. Well, she was a temptress. I couldn't resist. She knew what she was doing, etc. The bright line was not so bright then. I think it's a testament to how far we've come since 1977, that the kind of deal, the plea deal that he had in Santa Monica, California in the 70s would never be accepted now, simply never. Whether or not he should be an international fugitive and the American government should spend millions chasing him down, that's another question. But the notion of a child having a body worth protecting and a child being protected by the law against men of influence is a recent event and one to be noted.
We're almost out of time. Let me ask you one last question. We're now 12 years into the 21st century. We have a president who says that same-sex couples should be allowed to get married. Incest is still a taboo, certainly. Sex with minors is arguably more a taboo than ever. Mm-hmm. Men can be found guilty of raping their wives. Pornography is more accessible than ever. I could go on here, but my question is, so where are we all going as a society? Are we perhaps more pagan-like now than we were 100 years ago, with certain vestiges of Puritanism thrown in, or is it more complicated than that?
Oh, I think it's a lot more complicated than that. I'm not sure if we're pagan, except other than we're setting priorities in a different way. One of the things, the future of sex law, if the real developments are going to be the continuing adjustment of our society to transgender relationships, to gay, transgender, queer is a whole new category people are adopting, but also I think really biology. The notion of the rights of people who were conceived through artificial insemination, surrogate motherhood, our ability, and it is an ability, unprecedented, to move along and change the reproductive process is going to challenge traditional rights of parents and children in ways that I can't imagine. I have friends in France who are working on these issues. They're in a very big way. The French government and the European governments are really focusing on this far more than we are here. We're still stuck in stem cells and whether or not they should be used to prevent disease. But the real developments to keep an eye on are going to be the removal of sex as we know it from the reproductive process, and whether or not the results of those efforts are going to carry with them the same rights, liabilities, and consequences that traditional reproductive relationships have always had.
Eric Berkowitz, thank you so much. It was a treat.
It's really fun to talk with you. Thank you.
Okay.